Good morning, everyone, and welcome to the first full session of the Legal Cheek Winter Virtual Vacation Scheme in partnership with the University of Law. My name is Sophie Antian. I'm the Senior Events Coordinator here at Legal Cheek, and this morning I'm joined by Will Normand, a partner at Travis Smith, and Andrew Scott, a barrister at Blackstone Chambers. Now, over the course of the next hour, Will and Andrew are going to be giving a big picture commercial awareness overview for you. So this year we've seen some key trends, including ESG and tech. And so during this session, Will and Andrew will each be giving a talk showing what they see as the big trends for 2022 and the commercial awareness topics that you will need to have on your radar. So this is a great first session for you all that you can go on to use to contextualize the rest of the scheme as we go on during the week to focus on specific practice areas. Now, after Will and Andrew have given their talks, we'll move on to a Q&A. So do make sure you pop any questions you've got for the speakers in the chat bar on the right-hand side, because if we have time, I'll be putting some of your questions directly to the speakers. But during the Q&A, we'll be looking more at Will and Andrew's career journeys and looking at how you all can be building your commercial awareness and thinking about these things as we head into assessment centre and interview season. But for now, I'd like to properly welcome our speakers. Will and Andrew, thank you so much for joining us this morning. And Will is going to kick things off with his talk first. So Will, it's over to you.
Thanks, Sophie. Thank you all for taking the opportunity to dial into this and listen. I'm also, as well as one of the investment funds partners at Travis Smith, a member of the graduate recruitment panel. So I'm one of the annoying people who ask the commercial awareness questions. And when I was thinking about what would be useful for today's session, bear in mind the time that we have, I thought I'd focus on a particular area. In terms of what's on the horizon for 2022, there are a whole range of items that we are all thinking about and having to think about, not least the global economy's response as we, fingers crossed, come out of the pandemic and move to an epidemic, and the various implications, especially when I think about it in the context of a commercial law firm, that us and our clients are having to face. That said, I think there is a longer theme, a more long-standing theme that will outlast even the pandemic, as difficult as that may seem right now, and that's ESG, environmental, social, and governance. I'm sure you've all heard of this and it's referenced everywhere. But one of the things that I think is quite difficult to contextualize is what ESG actually means in practice, in my context for a city law firm and our clients. So what I was going to do today was drill into that in a bit more detail. ESG is part of the daily lexicon now, especially on environmental issues, given the news around COP26 taking place in Glasgow earlier this year. It is important to remember, though, as difficult as it seems now, that ESG, in terms of the sort of daily discourse around it, is a relatively new phenomenon. Certainly in the last 5 years, it's become much more prevalent. But even if you look back to sort of 2012, 2013, 2014, there wasn't a huge amount of reference to it. And it wasn't necessarily something that people were thinking about to the level that they are now. It now, frankly, dominates the daily discourse in just about everything. But it is quite, as I already said, it is quite difficult to pin down what this actually means in practice. In summary, it is forming part of something of everything that all of us do every day in the context of our practices at Travis Smith, and that will be the same for law firms across the country and frankly across the world. So in preparing for this talk, and in terms of drilling down what ESG actually means, I've spoken to colleagues about how it is impacting their practice areas and their clients. This will not even hope to be a definitive list of what ESG actually means in practice, because frankly, none of us have got enough time to go through all of that. And frankly, you won't even realize a lot of things that are going on unless you operate in a particular practice area or an industry. But hopefully what I will cover is a general overview of the types of things that people are thinking about in this context, so that if you come to talk about ESG as a sort of a commercial issue or a live issue when you're doing interviews or assessment centres or the like, it'll give you an idea about how you could frame this actually, in terms of how it works in practice, rather than as a theoretical acronym. So with that in mind, I'll sort of move on to the detail. And the way I was going to do this was divide it up into three sort of core areas. One is the impact on general operating businesses, your trading companies, your larger financial institutions and the like. Secondly, then looking at it in the context of the asset management and investment funds industry, which is a real driver behind the ESG agenda. And then thirdly, looking at some of the risk aspects around ESG and what it means to people in practice. So taking the first of those, what does ESG look like for our sort of corporates or institutional clients? Now, of course, the issues that any individual business will face will vary depending on what that business does, its size, the industry it operates in, and such like. But there are certain common themes that will pop up in more than one specific area. At the very sort of tip of the ESG iceberg, if you like, is the stuff that you can perhaps see quite easily day to day. Increasingly, corporates are being asked to report on ESG-driven strategies. You just have to look at the Companies Act to realise that in part of annual reporting these days, UK companies are required to give certain information around their ESG strategies. But this is very much the sort of tip of the practical implications of this iceberg. So what are some of those issues that businesses are facing? But if you start with employment and the treatment of employees, now this is very much on the S of ESG, the social aspects. But employers are having to deal with issues around ethical workplaces, inclusion policies, whistleblowing, and what we're increasingly also seeing is staff investigations where behaviour might fall below what are now the required standards. This works both ways because, of course, employers are having to think about being fair on all sides. It's also impacting regulation around employees. So for FCA regulated businesses that are subject to sort of senior managers regimes, their senior managers or risk takers are now required by regulation to have their bonuses subject to clawback or return mechanics if they are removed because of malfeasance or other sort of bad acts. So it's impacting both in day-to-day practice in terms of what employees and employers expect, but also that regulatory side is increasingly coming in. Linked to this, there are various bits of legislation that have come across in the last 4 to 5 years that are very much part of the ESG agenda. If you think about anti-bribery policies and anti-corruption policy laws, human rights and modern slavery, and various aspects of financial crime legislation, that is all essentially driven by the increasing focus on governance in particular within operating UK businesses. Tax is also a really important and frankly interesting area of the ESG agenda. And I suppose that probably falls within 2 main categories. In terms of the governance, there is very much a concept these days in terms of tax of paying your fair share. Now, if you think back to sort of 10, 12, probably longer years ago, tax was very much driven by what is legal and what is not. And there were always loopholes in tax legislation. And there was very much a game of cat and mouse between taxpayers and tax authorities, whereby taxpayers often, and this is in the corporate aspects, would find a loophole that would be subsequently shut down by tax authorities and you'd move on. And that continuous game would to a certain extent continue. Now, there is nothing that's changed in law today that means that shouldn't be the case. What has changed is there very much now is more of a public relations or general perception issue that applies to how a corporate behaves with its tax affairs. You only have to Google Amazon or Google in terms of their own tax affairs to realize how much public and political oversight is now attached to businesses of that like in terms of how they conduct their tax affairs. So both of those businesses have historically channeled a lot of their revenues through lower tax jurisdictions, which is entirely legal, but that hasn't stopped them being heavily criticised and pulled up in front of parliamentary or government authorities around the globe to criticise how they've behaved. And in many parts, that has changed their behaviour. This is very much part of the sort of whole governance agenda in terms of compliance of law, perhaps just isn't enough anymore. Linked to this, there's a global oversight authority called the OECD, which is working on a project to harmonise, to the extent possible, minimum levels of corporate tax rates across the globe. So you might have seen earlier this year, there was an announcement of a large number of jurisdictions signing up to a minimum 15% rate of tax for corporates. It's very much around these ideas of the Google and Amazon taxes in terms of not the internationalization of the economies and global business, is that actually to make this work, and this is actually another overarching theme of ESG, operating as a single jurisdiction perhaps and probably isn't going to be enough going forward, certainly for a number of these larger, in particular, tech-enabled businesses. But it also does happen at a more localized level. So in the UK, larger corporates are now required to report on their tax strategies as part of their annual report. That is explaining how they approach the concept of them paying tax, very much going back to this idea of paying a fair share. Employees in the UK companies are now also required to be subject to various training around tax avoidance and spotting it and reporting it. the pressure is coming on from all sorts of different aspects. So that's the first aspect of tax in terms of, I suppose, like a stick, if you like, to enforce certain governance issues. But it can also act as the carrot, in particular around environmental issues. There are long-held practices within the UK tax regime, for example, of providing certain tax breaks for renewable energy infrastructure projects and the like. Tax can be a driver to pushing businesses to behave in a certain way. If they can generate greater profits that are taxed less or subject to sort of certain tax breaks, then they will be encouraged to do it. So tax can also be a driver, in particular on the environmental side of ESG, to encourage those behaviours that, frankly, we all need to ensure that the COP26 targets and the like in the future are met going forwards. Tax, though, isn't the only driver of behaviour change, and we're seeing other areas where change can be encouraged within certain businesses. So, for example, in finance, so we are seeing an increasing number of what are called ESG linked facilities. So that is where a lender, and that could be a traditional bank or financial institution, or it could be alternative lenders that have increasingly grown up in the market, such as investment funds, which I'll come on to talk about shortly, act as lender to corporates who act as borrower. And these ESG facilities essentially have a variable rate of interest. And the interest reduces if certain targets around, in particular, environmental issues are met by the underlying borrower. It's an encouragement for those borrowers to behave in a certain way, meet certain targets, for example, around decarbonisation or environmental impact, and that thereby reduces their interest payments to the lender. The money that they save on the reduced interest payments are then required, in some or all cases, to be put back into environmental-driven projects. So what you're seeing here is not only governments through the tax regime encouraging or pushing the right behaviours, you're also seeing financial institutions do the same thing. They are aware of the ESG agenda and in many parts are being looked at by their own investors or backers to enforce that through their own day-to-day activities. Finally, on this area, I wanted to touch on competition law. Not necessarily an obvious area you would think about when thinking about ESG, but there is a valid question of to what extent is cooperation within industries or between competitors acceptable to drive, for example, environmental targets. These meeting environmental targets will have a financial impact on a number of businesses, and clearly, often there will be a big cost to them of doing that. To what extent should those businesses be able to cooperate in setting their own sort of agreed minimum standards so that they are both, all the businesses within that sector are operating almost on an even playing field, if you like, in terms of their costs? In an EU context, the European Commission is all very aware of this and has acknowledged the need that they will need to publish more guidance on it going forwards, in particular around cooperation agreements related to pursuing sustainability objectives. So it's something that very much will be on the agenda going forwards. There are even some investigations already going on in the competition space around ESG issues. So for example, in the UK, there's an announced investigation into the supply of electric vehicles and charging points around motorway services stations. So it's not, the regulators in the competition space aren't going to give industry full remit to essentially cooperate with one another to do this. They are going to be looking at this in terms of anti-competitive behaviour. And in a nascent area that is developing all the time, that's something that businesses that operate within particular sectors will need to be very aware of. So that's the first area of sort of trying to contextualize ESG. And the second one that I'm going to come on to now is the asset management and investment funds industry. So the asset management industry covers a huge remit of different types of financial institution, but broadly, it covers investment funds that are pooling together people's capital in different forms and investing it in underlying investments. Now that could range from just investments on stock exchange investments in shares that are listed on stock exchanges, through to what are called alternative assets. That's your private equity, private credit, infrastructure, real estate, through to a whole range of other strategies such as hedge funds that use sort of financial derivatives, but largely are doing something in between the other two. Now, why is this important in an ESG context? It's important because investment funds together across the globe manage trillions of dollars worth of capital. They have incredible influence and incredible level of oversight of much of the financial services sector. So they are important just generally to the global economy. But then when you think about it in the ESG context, how are they being impacted? And it's really in two forms. The first is that the funds that have been launched themselves and the strategies that they're investing in. So every investment fund will broadly have an agreed remit of investments that it can make. And what we're increasingly seeing is investment funds that are dedicated to strategies that are driven by the ESG agenda. So you're seeing funds launched to invest and finance renewable infrastructure projects, for example, or decarbonisation. The London Stock Exchange, for its listed funds market, is in the process of launching a market where the funds will pay for funds that will pay dividends not in cash but in carbon credits. Equally, there are funds set up with a social agenda in mind. So, for example, funds that provide social access housing or attempt to reduce homelessness in return for government grants, and that's how they get their income. So there's a whole range of strategies that are growing up because investors want access and people want to invest their money in financial products that are essentially seen to be doing good within the context of ESG criteria. The other area where this is really important, or the investment funds industry has a real important impact on ESG, is in the context of how they behave to their underlying investments. So if you take private equity, for example, which is a huge industry, private equity essentially are funds, capital managed by large financial institutions that essentially own private companies. Now, in terms of that ownership of private companies, they typically hold for a relatively long period, 7, 8, 9 years, not being uncommon. They have board rights to sit on the boards of those underlying companies, and they have total access to their information. This puts them in a really strong position to push the companies that they own to pursuing the right way of operating their business, be it from an environmental or a governance or social aspects as well. And there are all sorts of things happening around that. Again, just taking private equity as an example, we've been working with a group called the Chancery Lane Project that is seeking to harmonise investment terms, private equity investment, with harmonise the terms that relate to environmental, social and governance issues to try and drive best practice within the industry. And that is developing at a rate of knots. With that context in mind, though, one of the really important things for asset managers who are looking at ESG is that they are saying they are behaving in a certain way as regards ESG agendas because they want to attract capital for them to invest. So they want to attract investors to give them their money to invest in a certain way. And there is no doubt that saying they are investing in a sort of ESG friendly manner is a way of attracting more capital. But that clearly gives rise to the issue of how whether they are actually behaving in an ESG sort of compliant or friendly manner. And there are huge projects going on both in the EU and the UK around the harmonisation of how asset managers report their own ESG criteria and performance. This is an incredibly complicated area, not least in terms of how to gather data in a harmonised way that allows like-for-like reporting. But it is a focus, and the so-called greenwashing, which you might well have heard, is what it's trying to eliminate. So that is people saying they are doing one thing as regards ESG, but in fact doing another. And that then nicely takes me on to the final area of ESG issues to be thinking about, which is the risks around ESG. I think there are three hot topics that we're really seeing around the risk landscape of ESG. The first of those is new claims, in particular parent liability claims, but also value chain litigation, increasingly be launched with an ESG focus in mind. So, for example, and none of these have actually reached court yet, but we're aware of numerous claims out there being launched around trying to pierce the UK corporate veil, whereby the claim says that a UK domiciled parent company should be responsible, for example, for the operations of its overseas subsidiaries. That could relate to human rights issues, value chain litigation, or similar things like that. Now, those claims are interesting because they are going against very long-standing principles of law that they're essentially attempting to challenge. And the question that obviously jumps to mind is, well, why would you launch those claims when it's against such a well-established legal principles? And again, it comes back to what I mentioned on the sort of tax aspects of this. There is a PR issue here. No one wants to be subject to these kind of claims. So even if it goes against very established principles, query whether people are going to start launching these claims to try and force behavior, even if they don't think legally they might win because of the damaging reputational aspects of claims being launched in that manner. The second area where we're seeing in terms of the disputes and litigation is climate change mitigation action. So this is very much a global issue. For example, in the Netherlands, a claim has been launched against Shell relating to its own carbon reduction targets. And in the UK, you're seeing public law claims, for example, around the Heathrow third runway. So again, people are using the courts to try and drive these behaviours. And then the final aspect, and I've alluded to earlier, to greenwashing, is the potential risk for businesses that say one thing as regards ESG and perhaps do another, or say something with the best of intentions, but can't actually deliver on those promises. We think that there will be a huge run of litigation around people claiming losses from investments or perhaps even operations where a business says it does one thing on ESG and actually does another. Now, who knows where that will end up, but already it's very relevant in the financial services space. As I've said already, asset managers are increasingly subject to reporting requirements around how they behave on ESG, but we think this will spread to commercial and operating companies going forwards. So there's a huge range of risks for businesses that say things about their ESG if they can't actually deliver on it. And we're spending a lot of time advising clients and making sure that they are suitably the way they disclose what they are doing actually reflects the practice and what is actually achievable. So that is a real whistle-stop tour. There's a lot more that we could probably talk about in ESG, but hopefully that gives you a context to what ESG actually means in practice in the work that a law firm is doing. Sophie.
Fantastic, thanks Will. And we'll be hearing more from you a little bit later on in the Q&A, but for now I would like to invite Andrew to join us up on stage for his talk. Perfect. Over to you, Andrew. Andrew, you're just on mute, sorry.
I'm so sorry.
No problem at all. Thanks,
2
Andrew.
years into this. And
happens to all of us, don't worry. Thanks, Andrew.
Good morning, everyone. I'm very grateful for the opportunity to speak to you all today, particularly now I've taken mute off. I'll address 3 things. First, some brief remarks about how I came to the bar and what my practice focuses on. Second, and relatedly, some general observations about how the market for litigation relates to the wider economy and how that work impacts on the work that we see at the commercial bar at the moment. And then finally, some predictions about what seem to me to be the likely trends in commercial litigation next year. My path to the bar, I was called in 2010, so I've been in practice for just over 10 years. And before I came to the bar, I was an academic and I specialised on international law, private international law topics, particularly as they impact on commercial cases. And that's basically been the field in which I've practiced since I came to the bar. And my impression of the litigation market in London, with which I'm most familiar, is that most commercial cases nowadays involve one or other international element. And that really informs some of the trends that I think I've seen certainly in the last decade and which I expect to see going forward. So why is commercial litigation work in London international in nature? I think 3 main reasons. The first is the nature of the UK economy, in particular the services sector. This is, and still is after Brexit, inherently international in nature. There are very many service providers based in London working for international clients, and out of their work stems litigation, and much of it comes to the UK courts. Just to give you a few examples of my clients in the last year, I acted for a Luxembourg fund sitting under an Australian bank, for an Indian steel multinational, and for a series of Delaware limited liability partnerships investing in a foreign arbitration seeking to enforce the arbitral award in London. And that is the type of commercial work that I think characterises the cases going through the commercial court and through the Chancery Division at the moment. The second reason why I think you see international work in the UK legal services market is because of the nature of how legal services are provided here. I mean, at the bar, our immediate clients are in most cases solicitors, and most of the solicitors I work with are firms with an international presence. Some will be UK firms, others will be US firms, but they are all trying to capture litigation work from around the globe and to bring it to the UK for resolution here in our courts or in arbitration. And the third factor which makes litigation work international is the reputation of English law and English judges in the context of commercial law. It is these things that cause parties to choose English law and jurisdiction or arbitration for their contracts. And it's the same things which attract foreign litigants in seeking to establish jurisdiction here. And particular features of the process that are attractive, its relative certainty in commercial law, the availability of interim relief, freezing injunctions, and so on. The approach to disclosure in England, not quite as extensive as in the US, not quite as light touch as in mainland Europe. The forensic process, cross-examination, the cost recovery regime. All of these are factors which have contributed to making the UK an international litigation centre, and which I would expect to see contribute in the coming years. With those introductory observations, let me turn to my second topic, which is litigation and its interrelationship with the wider economy. Now, to some extent, litigation is counter-cyclical. It is often said that when the economy is up and people are making money, there's little appetite to spend it on litigation. And in my experience, there's some truth in that. I began practice shortly after the global financial crisis in 2008, and there was a considerable amount of commercial litigation that arose in the following decade, particularly between financial institutions, that I think we would most likely not have seen had the relevant markets still been operational and profitable. Another facet of the counter-cyclical nature of the litigation market that one sees is that there's a fair amount of insolvency-related litigation in the UK when the markets are down. Claims by stakeholders, bondholders, and so on to recover from those said to be responsible for the collapse of the relevant business. And again, I saw a fair amount of that after the global financial crisis. And I would expect to see that work come back in the next couple of years as a result of businesses falling over following COVID. But I don't think you can take the counter-cyclical point too far, particularly at the moment. And three main reasons for that. The first is we're in a very different global economic world now from the situation in 2008. We've had more than a decade of quite loose central bank policies around the world, and the consequence is that in many parts of the global economy, there's lots of cash sat on the sidelines waiting to be invested. And we see some of that investment appetite in the growing litigation funding market that one sees in London. But my sense is that those with cash probably think they can find better things to do with it than to pay the lawyers. The second thing is that we've seen the strong emergence in the past 10 years, insofar as it wasn't already apparent in 2008, of tech giants. And the litigation market is still getting to grips with that, and the picture is a developing one. But just to give you a few examples of what one is seeing going through the courts at the moment, in the commercial context. The first is patents litigation between tech giants. I'm involved at the moment in litigation going through the courts in Europe and in the US between the world's leading mobile phone providers. They are experienced with 3G litigation and 4G litigation, and 4G and 5G litigation is now coming down the pipeline. And because patents are territorial, litigation like this tends to take place in many places at the same time, and the UK is well placed to pick up the European leg of the disputes. The second potentially growth area that I think we will see in the context of litigation and tech work is on the competition and regulatory side. I think it's fair to say this is a fairly nascent market, at least in the UK, and competition is not really my area, but my impression from colleagues is that in the next 10 years or so, we are likely to see much more competition and regulatory work in the tech field, and that's likely to generate litigation work in due course. And the third reason I don't think one can take the counter-cyclical point too far is what the economists might call black swan events. Events that are not foreseeable, but which, when they occur, change the landscape fundamentally. Now, two recent and obvious examples of such events, Brexit and COVID, and each has impacted the litigation market, and I would expect will continue to do so over the coming years. I come then to trends in litigation for 2022, and I'll identify four. The first is Brexit litigation. Untangling the UK's legal system from UK law is going to take time and cost considerable money for those who must litigate it. Now, you might think that commercial law would be largely safe from the impacts of Brexit, but that would be wrong. Just to take a single example from my practice, jurisdictional disputes. All commercial cases begin life, at least in the context of litigation, with thinking about what the right jurisdiction is, what the most appropriate jurisdiction for your client's interests to pursue the litigation. Now, since about the late 1970s, the UK's rules on jurisdiction have been derived from EU law, and that changed at the end of December last year. And the implications are profound. Our law is now domestic only, and the relevant domestic rules really lasted service in a commercial world that was very different from the one we now find ourselves in. Our domestic rules on jurisdiction were largely settled in the late 1970s, primarily in the context of shipping disputes. Now, that type of work has primarily gone in the UK litigation market. Those sorts of disputes tend to be arbitrated, and they tend to be arbitrated in Singapore or Hong Kong rather than in London. And there is a very, very much greater focus nowadays on fraud litigation in the international context in English courts. And I think that is a growth area for jurisdictional disputes, parties having to work out with the court's assistance how our domestic rules on jurisdiction are going to apply to the new types of dispute that are going through the English court. And to give you just a single example of that, I spent the last 2 weeks in a 6-day jurisdiction hearing in the Chancery Division in the context of a fraud case. It was all about the uncertainties arising out of Brexit. Now, had that case been brought prior to the 31st of December last year, I think it most likely would not have got to court on the dispute about jurisdiction, or if it had, it would have been resolved in about half a day or a day. And yet, the law in which we find ourselves now is so much more uncertain. There is much greater room for argument. We took 6 days before the judge. It wouldn't surprise me if it goes on appeal for 3 or 4 days. So that's the first topic where I think we're likely to see litigation in the coming year. The second is obviously COVID-related litigation. The Supreme Court last year heard a very substantial business interruption insurance dispute that was driven by the FCA. That was focused primarily on the small business market to sort out what standard policy wording in that context means for small businesses. And that's gone a long way to resolve quite a lot of the disputes in the insurance sector, which had been in the market last year. But what it hasn't addressed is the larger players in the market. Hasn't really addressed the reinsurance market at all. And I would expect that in that context, in the next 12 to 18 months, there are likely to be some quite large bespoke arbitrations arising out of the uncertainties that COVID creates for insurance policies and how they operate in this uncertain world in which we find ourselves. I think we're also likely to see contractual disputes. Courts are going to have to grapple with how force majeure clauses operate in the COVID context. The third trend I think we're likely to see, and this picks up on Will's point about litigation as a vehicle for ventilating PR disputes. Over the course of my time in practice, I've seen an increasing number of commercial cases in which it might fairly be said that the claimant's interest is not primarily in recovering money, but in using the court process as a way of investigating ESG issues or human rights issues, and using novel and creative legal theories to encourage the English court to do that. Just to give you 2 examples of that. I'm involved in a case at the moment in which the claimants are some 7,000 Malawian tobacco farmers who have brought claims against UK domiciled parent companies, seeking to hold them liable for alleged malpractice on the tobacco farms in Malawi. Now, if you were to apply settled principles of tort law, I think it's fair to say that is an extraordinarily difficult claim to make good. But that is little comfort to UK parent companies having to defend allegations of the type that are being ventilated in that case. To give another example, Facebook has recently been put on notice of claims arising from victims of terrorist atrocities in Myanmar. The allegation being that Facebook failed to do sufficient to control the use of its platform to facilitate those atrocities. Now, that's the type of litigation that I think one wouldn't have seen 10 years ago, but I think that will increasingly dominate the litigation landscape in the UK in the coming 5 to 10 years. And the final theme I expect to see over the coming year is fraud litigation work. And I think this is an area in which there is an interrelationship between what the economy is doing and what you see in the litigation market, because you tend to see an increase in fraud work at the lower end of the economic cycle. And I think we're seeing that coming through the courts now. Certainly my own practice, I will be in trial for all of January and February on a fraud dispute where the claimants are seeking to attach liability to directors of a company, which is now insolvent, on the basis that the defendants are, they say, fraudulent. And I think that type of fact pattern is fairly common. Cases where the claimants cannot recover against the natural defendants because it is insolvency, and therefore they are forced to recourse to more creative and more difficult liability theories in order to recover. So I think that brings me to the end of what I was planning to say, and I'm just 1 minute under time.
Fantastic, thanks Andrew. So now I'd like to invite Will back up on stage and we'll get into the Q&A. Perfect, thanks Will. So following on from both of your talks, I wanted to turn to the poll that we've got going and get the audience's views on the big commercial awareness themes of 2022. So the question that we've got today, and everyone in the audience, if you click on polls in the right hand side, you'll see the poll that we've got in today. And that question is, what will be the biggest commercial awareness theme of 2022? Is it ESG, tech, the post-COVID new normal, or inflation and fiat money devaluation? Now, looking at the audience responses, Will, you'll be very pleased to see that 53% of the votes have gone to ESG, followed by 28% of the votes with the post-COVID new normal. Tech only has 12% of the votes, and inflation and fiat money devaluation has 5% of the votes. So we've covered ESG quite thoroughly this morning. So I'd be interested to hear your thoughts on tech. Tech's got 12% of the votes.
Mm.
Will, Andrew, do you agree with the votes of the audience? Do you think tech is something students should be focusing on?
I'll go first. I think slightly unfair, but I think all of them are actually one and the same thing, because actually when you think about the ESG agenda, so much of it is related to tech, be it globalization, be it sort of moves to a digital economy, but the tax points, there's a lot of overlap is the reality between the two of them. And again, tech is one of those entirely nebulous concepts that actually you can probably apply to just about everything. If I look at my client base, one of my clients was a traditional equities investor, but moved to investing into tech, late stage tech businesses that are increasingly dominating daily life. You just have to look at what some of them are doing. So, yes, I do agree. I think ESG is going to remain high on the agenda. The COP26 effect isn't just going to go away in terms of what people are talking about, but actually, I think a lot of those other things, including in many ways the response to the pandemic, will feed into ESG anyway. I think there's an inevitability that they will all overlap with one another.
Thanks, Will. Andrew, do you agree there?
Yeah, I think so. I think it's quite difficult to hive off tech as a separate category. I think the litigation market is to some extent slightly behind possibly what Will sees. I think we are not yet in a golden age of tech litigation in London. And I wouldn't really expect us to be, because when businesses are growing, they've got far better things to do than spend a load of money on litigation. But I think
I'm making the problems for tomorrow.
I mean, just to give you a single example, there was a case in the commercial court a week or so ago about freezing injunctions in the context of Bitcoin. Now, it's an entirely traditional freezing injunction application, save for all the difficulties that the court had to grapple with about how Bitcoin fits in to our legal framework. And I think one is likely to see much more of that type of litigation, not less, as cases go on. But I don't think it will come in under a tech umbrella. I think you will just increasingly see that your clients raise issues which you didn't see previously. That's kind of part of your job as a litigator.
Fantastic, thanks, Andrew. And just looking at that last option, which was inflation and fiat money devaluation, which had only 5% of the votes, would you agree? Is that something that students should be focusing on? Or?
Well, I mean, it's going to dominate our daily lives, whether you realise it or not. The rising cost of living is, and the inflationary aspects of that, or causes of that, is going to be huge. I mean, I think it's probably more difficult to apply it to what Andrew and I do, I suspect, day to day, because this is much more of a sort of macroeconomic issue that will impact all of us, be it as individuals or, in my case, my clients, or whatever it may be. But it's such a macro issue that I don't think you can sort of distill it down to a commercial awareness issue for people looking to come into a legal career, I suspect.
Andrew, do you have anything to add there?
No, I wouldn't.
Sure.
I have nothing to add about inflation and fiat devaluation.
Dangerous. Talk like probably is not where I should go.
So we'll move on to, I just wanted to pick up on a point. So Andrew, you mentioned a lot about COVID-related disputes in your talk. So Will, I just wanted to turn to you and ask, has COVID affected your practice and your clients' priorities? Has it perhaps acted as a catalyst for more of a focus on ESG?
I don't think it has acted as a catalyst on the ESG side. It definitely has impacted my clients. So, if you look at the last 2 years, there have definitely been phases of just the way in which clients have been impacted, but and of course, across the firm's work, the employment issues that came out of furlough and such like, and now the various aspects around the sort of future investment, the tax regimes that apply. There's all sorts of issues that have impacted. I think, much like the rest of daily life, what has COVID done? In many ways, it has accelerated change that was probably going to happen anyway, but has very much driven it. You just have to walk up and down your high street to realize how much change has been accelerated, he says, with Amazon Fresh just having opened up on his doorstep, because that's now the way we're operating in life. So I think it has definitely driven change, and that is on our day-to-day lives in terms of what's happening on the high street. But it's also accelerated it in terms of the clients that we focus on, and where the potential opportunities for us as a law firm lie. So much of these businesses, the traditional businesses, it inevitably are having to change at a much greater rate. I read something this morning that said 60%. There was some estimate by someone who knows these things far better than I do, but some 60% of jobs that will exist in 20 years' time don't actually exist now, as an estimate, which is a slightly terrifying thought for someone who is still intending to be working in 20 years' time, kind of hoping mine still exists. But that just goes to show that, and if that sort of thing is happening, that is impacting what we do day to day, and so of course it is driving it. I think it's probably stuff that would have happened anyway, but it has definitely been accelerated.
Thanks, Will. So we're going to move on to now look a bit more about both of your career journeys and hear a bit more about how you got to where you are today. So perhaps, Andrew, if you could start off and talk us through your career journey, how you came to be a barrister. Is this what you expected to be doing when you were a student?
Yeah, I think it is pretty much what I expected to be doing when I was a student. I took a slightly unusual route to the bar. I stayed on at university for quite a while, researched law, taught law for a bit, and I found that the topics that interested me, both for research and teaching, were effectively litigation topics. And I was conscious that a point would come where I thought it would be more fun to do those things in practice rather than to read about them. And when that point came, I went to the bar, and so it has proved. I mean, it's a really great career. It's a difficult career, but it's a really interesting career.
Fantastic, thanks, Andrew. And Will, how about you? If you could take us through your career journey.
Sure. So I've probably done quite a traditional route of ending up in a city law firm. So I did a law degree at Warwick, and then I trained at Herbert Smith and did 6 years there as they were then. And then I've been at Travers now for a decade or so, 7 years as a partner. I think I did, I think, did it turn out like I expected? Probably, yes, I think it did. I think possibly like many law undergraduates, I'm going to confess that I suspect my career choices were less sophisticated and less thought through than how a lot of people think about it today, in that I did a law undergraduate degree. I turned up to a few presentations, and there, lo and behold, I was on the conveyor belt. Luckily for me, it worked out rather well. But there's something I actually wanted to do and found quite engaging. Like Andrew, I did actually start wanting to be a litigator when I started, which lasted about 4.5 days of my litigation seat as a trainee, when I decided that I was perhaps not cut out for the rough and tumble of litigation, and was actually probably better suited to transactional work of everyone trying to notionally most of the time work together. But yeah, I've been through a fairly sort of traditional path to fall towards it, and probably actually now in the minority of people who do that, because many others do different things or come from different backgrounds or different degrees. But yes, sort of it's and it's an interesting job. You know, like Andrew says, it changes all the time, and you have to roll with that. I think actually what makes successful people in this career now is actually a level of adaptability. It is not simply choosing one particular path to go down and saying, well, this is what I'm going to do for the next 25 years, because if you do that, you probably will become obsolete pretty quickly. And that presents its challenges, but also makes it a much more interesting career.
Thanks, Will. And it's great to have both sides of the profession represented this morning on the panel, with the solicitor and barrister with us this morning. So perhaps you could talk us through what drove you to become a solicitor instead of a barrister, and vice versa. What was your thought process there?
God, that implies there was a thought process. I don't know. I never really considered the bar, if I'm being honest. I have friends from university and law school who did and have gone on to make very successful careers at the bar. I think for me, I was always more interested in sort of transactional work. So that naturally pushes you towards a career on the solicitor side of things. So yeah, it was never really a hugely conscious decision on my part, but I think that I probably always had in the back of my mind that was more what I wanted to do.
And Andrew, did you ever consider going to become a solicitor as opposed to a barrister?
No. I think there were two things really for me that meant the bar was the right choice. The first was the thing I really wanted to do was advocacy, and there are advocacy opportunities as a solicitor, particularly in the international arbitration space. You can, have a fantastic career as an arbitrator in a law firm in that space. But in terms of court work, we are, whatever the rights or wrongs of it, we are still in a situation whereby one sees much more advocacy at the bar. And that's really what I wanted to do. And I think if that's not your reason for choosing between the bar and being a solicitor, you need to sort of, think quite carefully what your reason is. Because certainly for commercial litigation, if you take advocacy out of the picture, there is very little difference between the work you will do in a commercial law firm and the work you'll do, particularly as a junior commercial practitioner. I mean, certainly the early part of my career as a commercial barrister, I would often find myself working on part of a large team with associates at law firms, and we would be doing much the same sort of thing, because what the client wants ultimately is a team that works, and the client doesn't really care about what the composition of that team is. So, if a letter needs drafting and the associates are too busy on something else in the case, you'll do that as a junior barrister. If some documents need reviewing as part of a disclosure exercise, you'll do that. I think the difference comes, and it comes slightly later on in your career, when you're doing the advocacy. And that's the thing that makes a difference. And then I think there's a second order difference, which is you can lie to yourself quite effectively at the bar with this myth that you have greater flexibility. And I'm quite good at lying to myself. And so I persuaded myself that I would have much greater flexibility. And to some extent, it's true. I mean, to some extent, you know, if I want to take a holiday, it's my decision and it's informed by my diary. I don't have to clear it with anyone. I don't have to, you know, put in a request for annual leave. So in theory, there are additional benefits in terms of flexibility. In practice, finding a self-employed person who willingly takes holidays is very difficult, and I'm no exception.
It's interesting that, because actually, you know, to Andrew's point about divergence and convergence of the two elements of the profession, I suppose as a partner in a law firm, I'm basically self-employed. I mean, I work with all of my colleagues, but ultimately mine is part of the Travis Smith business, but it is something that I have to run. And ultimately you end up, well, technically I am self-employed as a partner in a law firm. And, you know, my client base, albeit it's one that operates with other aspects of the firm, ultimately see it in the same way, which is I'm paying you, Will, to give me a service. And so it's quite interesting. I think actually the more senior end of the solicitor's side of the profession, it probably converges much more with the bar in terms of that sort of self-employed, sort of self responsibility aspect. But yeah, I can see the point. As a more junior end, then obviously it's my problem, not yours, as a junior person within my firm, that I've got to make sure that your holiday works, whereas mine is a sort of bit of an optional extra, he says quietly, before he gets more criticism from his family that now downstairs and hearing me saying this.
Thanks, Phil. And it's really interesting to hear how the two sides of the profession can, in fact, start to converge. So in the last 5 minutes or so of this, I want to focus a bit more on commercial awareness. And I've seen a few questions come in the chat bar about how to build commercial awareness. So if we look at some practical tips on how best to build it, it's application season, assessment centre interview season. So Will, perhaps coming to you first, as a graduate recruitment partner at Travis Smith, how should people in the audience be thinking about building their commercial awareness?
Yeah, look, I don't think there is a single answer to doing this. So, you know, I would probably look at it from the other way, which is when I do an interview for a vacation scheme or a training contract, I'm very cognizant of the fact that the person I'm interviewing does not operate in the professional world yet. They are typically undergraduates or postgraduates. So, and I'm also very aware that it's very unrealistic you're reading the FT from cover to cover every day. So this whole, I remember back when I was doing this 20 odd years ago, slightly depressingly, that, you know, oh, everyone's reading the FT. I mean, no one actually does that, let's be honest. So what am I looking for when I interview someone around these sort of issues? I'm looking for someone who is engaged, aware, can hold a conversation, can debate the merits of something, probably not dissimilar to what Andrew's looking for, I'm sure I'll say in a second. So be aware, you know, we're very unlikely to spring a particular commercial topic on you. And if we do, it's probably one that frankly should be will be so well known that it shouldn't come as a huge surprise to you. So what I look for is actually someone who has an opinion on things and can talk around an issue and can debate something. So if you're going to introduce a topic, I would say have in mind that you're able to do that. Don't introduce something that you've literally read one article on. You don't, take to our previous points. If you're going to start talking about inflation, understand what that actually means in practice, rather than what Faisal Islam said on the BBC News at 10 last night and leaving it at that. So, you've got to be able to debate a point and talk about it. That's commercial awareness to me. And it also ties in with what else we look for in people, which is an interest and an ability to engage. To sum it up in one line, I have in my head when I interview someone, I have what I call the aeroplane test. Would I be happy with this person sat next to one of my key clients for an hour on an aeroplane with me not around? And that's nothing to do with their skills as a lawyer or anything like that. It's, are they an interesting person who can engage and be an ability to discourse with people? And that very much links into commercial awareness. It's part of that.
Fantastic, thanks, Will. Some really useful tips there. And I saw somebody else in the comments, Abigail Fernandez, had asked specifically, if you want to talk about something like ESG at an interview, should you look at that more holistically, or should you focus on different aspects of ESG? Up
to you. I want to hear what you find interesting when I have an interview. So there is no right or wrong way of doing this. It's all about an ability. If you're going to talk to something, be prepared to talk about it. And if you want to talk about ESG in a sort of global, holistic context, I'm happy to do that. If you want to talk about it in the context of UK tax regimes, I'm happy to do that. But you've got to be prepared for it. But I don't think there's a right or wrong answer. And I think, interviews aren't a sort of tick box exercise, and I think it is, and frankly, if they are a tick box exercise, I'd be hesitant, to be working in a firm that was that, because I'm not sure, there should be no such thing as a one size fits all. What we're interested in is, as I said, a sort of to and fro in an interview and an ability to debate. We know you're academically right if you've got through all the stages you need to get sat in front of me, be it behind a screen or in person. So what I'm looking for at this stage is engagement, and there's no right or wrong answer to that necessarily.
Thanks, Will. Some really useful advice. And turning to you, Andrew, how would you go about building commercial awareness or demonstrating that in a pupillage interview?
So I think three things. Firstly, don't really bother with the FT guidance that one often sees given, because it's not realistic, and it's also, you're not being interviewed for a slot at an investment bank. You're being interviewed for a slot learning the trade in a set of chambers that does commercial work. I think the second thing, and this is the more positive answer, is think about, if you are interested in commercial law, think about how commercial issues underlie why litigation ends up being brought and why the outcome of litigation is significant. Now, often the answers to those questions are fairly straightforward. It's the money. One side wants some money, and if it gets some money at the end of it, it's very happy. But a lot of litigation isn't quite as simple as that. And I think often the most interesting answers you get at interview recognize the nuances. So, a really good example is Will's point earlier on about ESG issues arising in the context of commercial litigation, which of themselves are unlikely to generate a higher damages award. But the strategic power of knowing that if the case goes to trial, the CEO will be there answering cross-examination about ESG issues. That's the thing that will make the case settle. It's got nothing to do with the legal merits. It's got nothing to do with the principles. It's the fact that at some point, someone is going to have to write a memo to the CEO that says, you are being cross-examined on Wednesday X, and you will be asked the following sorts of questions. And that's the point at which the CEO and the board will say, no, we settle this. And then the third thing I would say is, I think what most interviewers are really testing for, at least at the bar, and I'm sure it's the same in law firms, is a sort of degree of shot selection at interview. The really impressive candidates are the candidates who know their own material well, know the things that they want to talk about, and they sort of use the interview process as a vehicle to talk about those things, rather than getting caught on topics that they don't really know anything about, or examples that they don't really know anything about. One of the worst interviews you see is where a candidate gets bogged down in an answer or an example that they're not really interested in, they don't know a great deal about, and they just don't have the material to back it up. And the error that candidate made was starting off down that track at the beginning of the answer. So they've just taken a minute or two to think about it. So to take the person whose question is about, do you deal with ESG holistically or specific aspects? It depends. Depends what you know, depends what you're interested in. Just try and play to your strengths.
Fantastic. Thanks, Andrew. So unfortunately, that's all we have time for this morning's session. An hour has gone by so quickly. But everyone in the audience, don't go anywhere yet, because we now have some virtual networking for all of you. But before I explain how all of that works, I'd firstly like to say a very big thank you to Andrew and Will for joining us this morning for a really useful session. And Will and Andrew, you'll see hundreds of thank yous coming in the chat bar any second now, I'm sure. But for all of you watching, just to flag that we have our second session of the day taking place this afternoon from 2 till 3, and that is on understanding the corporate legal market with speakers from Osborne Clarke and Ropes and Gray. Now, this session has a case study attached to it, and that was emailed to you yesterday evening from the Legal Cheek team. So do make sure you have a look at that case study, as the speakers will be taking you through that in the session this afternoon. We also have a social plan for you, and that takes place from 6 o'clock, and you'll hear a little bit more about that later on this afternoon. But like I said, we'll be back here on stage at 2 o'clock for our second session of the day. But now, like I said, it's time for virtual speed networking. So in just a second, everyone in the audience, you're going to click on networking in the left-hand sidebar. And when you get there, you'll be randomly paired with somebody. Now, that could be me or someone else from the Legal Cheek team. That could be another student taking part in the scheme, or if you're very lucky, that could be Will or Andrew, who I think has just headed over there now. But once you're paired with someone, you'll have 3 minutes to network with that person and chat to them before being randomly paired with somebody else. And you can keep going for as long or as little as you'd like. So this is a really great networking opportunity to get to know other people in the scheme and have the opportunity to chat one-to-one with our speakers. So now I've explained how all of that works. A final thank you to Will and Andrew for joining us this morning. And everyone in the audience, if you just want to click on networking in the left-hand sidebar, get speed networking, and we'll see you over there. Bye, everyone.